Joining us for more insight onto the trial, attorney Alexandra Kazarian. Alexandra, thank you so much for being with us. So there's a lot of debate over what Alec told authorities on scene there. Prosecutors went as far as replaying that clip. We just heard an Evans piece there. They have slowed it down. We're going to listen again. Let's listen.
So bad. It's so bad.
All right, Alexandra. So in just the past few minutes, we've now heard this 3 times. The first time I heard it, I thought I heard I. Now I feel like I'm hearing they. How important is this particular word in the big picture of this case, particularly for these jury members?
Well, since there's such a lack of actual physical evidence tying Alex Murdaugh to the shooting, they don't have that murder weapon. They don't have somebody coming in to say, we saw him with that in his hands. They've got to rely on this circumstantial evidence. And so if the jury believes that he's sitting there being faced with the death of his son and he makes this confession, if they believe that, that could be a really solid piece of evidence for the prosecution. But when it comes to circumstantial evidence, they're going to get a jury instruction that tells them if you have circumstantial evidence and there is one theory that points to innocence and one theory that points to guilt, and if they're both equally reliable, the jury has to pick the one that points to innocence. So if that's the only evidence, if that's the biggest piece of evidence that the prosecution is going to have against Alex Murdaugh, it's not going to be very strong, because the jury is going to be told by the judge, not just by the defense, but by the judge, that if they believe there's a chance that he could have said we, or that he meant that he failed him as a father and it wasn't a confession of murder, then it's not going to be strong. Not only is it not going to be a weak piece of evidence, but they cannot use it. So it really depends on how much other evidence there is in the case.
All right. So based on what you just said there, it seems pretty clear. Are you surprised the defense didn't make a bigger deal about that?
I think that they're probably being very careful about how they argue and what they argue, and saving it for a closing argument, because the jury doesn't realize yet that they're going to be told that they cannot use that piece of evidence if they believe it might point to innocence. And I think that's a big piece of information to give to a jury at closing argument. And you don't really want the prosecution to know that you're going to hammer them on that. I'm sure the defense is going to hammer the law enforcement for not following up on that question. How could they not say, wait a minute, I'm sorry, did you just say that you failed him? Did you mean that you killed him, that you had something to do with his death? The fact that they didn't follow up on that, and that now the prosecution is saying, oh, well, it must mean this without anything to back it up, I think is going to be huge in closing. But you don't want to telegraph that so that the prosecution can fix it.
All right, that makes sense. You mentioned a big piece of information when it comes to that. Another big piece, this cell phone data, much of today focused on that, but it was really a lot of in the weeds technicalities. What is the prosecution hoping this information reveals? And possibly more importantly, can the jury even follow along when it gets so technical?
I think there is a problem with the jury following along. And I think that if the prosecution hasn't specifically laid out why they're giving this information, what you need to look for when they're giving you this information, if they haven't mapped that out for the jury, there's absolutely a chance that the jury is going to get lost. And I think the fact that if there were jury members that were laughing today, a happy jury doesn't convict. A happy jury is much less likely to take the prosecution's evidence at face value of guilt. They are going to be considering things. They're disconnected from the grit and the grime of the accusations enough to actually take a beat and laugh. That's good for the defense. So I do think that the prosecution has probably lost them a little bit on all this technical information. And again, the prosecution may be saving the big gotcha moment for their closing. They may be hoping that they're laying this all out and will tie it all up in their closing so that the defense can't really attack it. But I think with technical information like that, that's a big gamble, and they may have lost on that.
That was a really interesting tidbit there about a happy jury. Last question for you, Alexandra. This two-shooter theory that the defense is presenting, is this a strong move by his defense?
I think it is, because at this point, we don't know where the gun was. We don't know which gun it was. We don't know if that blood on Alex Murdaugh's shirt came from, him shooting. So if there is a chance that a jury may believe that he was close, but maybe not the one that shot, if there's an opening for the defense to argue that, then I do think it's a strong theory. And I think that because of the way that a lot of this evidence was handled, the way the crime scene was handled, I think there's a lot of openings for the defense to make that argument here and for the jury to believe it.
All right. Valuable information here, Alexandra. Thank you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.